Good day, Crime Talk aficionados. As you can see, we are back in the Crime Talk studios, and what do we've got to tell you today? First, police have arrested 5 individuals in connection with the 2023 death of Leandro De Niro Rodriguez. Yeah, the De Niro part gets people's attention, right? Idaho prosecutors push for full restitution in the Kohgerger case, despite the defense objection. Former Illinois deputy Sean Grayson convicted. Private investigators disclosed more items recovered from the singer David's rental residence. Austin Drummond is relocated to state prison due to some disruptive conduct. We've got This Day in Legal History, our quote of the day, which you're going to love, and our dumb criminal. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do. Leave me a comment below, hit that bell for notifications, and yes, go check us out on any of your favorite podcasting apps. Now, as you can see, we are in the Crime Talk studios today. Yesterday, we were on the road, and we did kind of an abbreviated show. Wasn't sure if we were going to be able to do a show at all, but that fired me up a little bit with the court's order in the Barry Morphew case, where basically the judge, she ordered it, that we're not going to live stream anything anymore because of a few bad actors who had live streamed it, even live streaming the admonition warning saying you can't do this under Colorado state law. People did it anyway, and now we're all screwed. It is frustrating. It upsets me, right? And on a couple of reasons, I'm also, don't like the court's order, but I get why she got there, because people weren't following her orders. It's like all things in life. There's always that one guy that's going to do something that just screws it for everybody else. And in this particular case, that JLR Investigates did that. I don't know anything about the guy. I've only seen a couple of videos. Like I said, maybe he just got over his skis. But based upon the comments, a lot of people think he's a little reckless, which maybe is why maybe the judge should prosecute him for contempt of court. But the judge basically said that would probably not going to happen. So therefore, she's going to punish all of us and we won't be able to see it. Now, I understand Barry Morphew has a right to a fair trial. Everybody is accused of a crime. And as, like I said, somebody that's done criminal defense for 30 years, I certainly want everyone to have a fair trial and have their due process respected. But in the same token, I also think that everyone should have access to the court system. And yes, if there's something that goes on, somebody should be able to take a screen grab or put that out there for the world to see. For all the reasons quoted in the court's reasoning as to why we have public courtrooms, to make sure the defendant's being treated fairly, making sure the prosecutors are doing their job, that they're getting a fair trial. We're not having hidden trials in some back room somewhere where nobody can see what's going on. That's what you do in like third world countries and, communist dictatorships and things like that. So I understand how the judge got there in the Morphew case, but I hope that she reconsiders, because I think the public's right to know and to make sure that the evidence, whether Barry Morphew is found guilty or not guilty, that the people can judge for themselves. So think about all the cases where everyone thought there was going to be trouble. The Derek Chauvin case as it relates to George Floyd. The Kyle Rittenhouse case, right? Everybody expected riots depending on how the verdict came out. But there were no riots because why? You could go every day and look at the evidence that was presented and what decision was based, was there as the basis for the decision, whether guilty or not guilty in those cases respectively. It's because the truth was out there. You want to protect misinformation? Put all the information out there so people can't say, oh, this is what we think it could be, and here's some tin hat theory of conspiracy theorist kind of stuff. These are the facts with legal and competent evidence. All right? Legal and competent evidence. That is the legal standard, admissible under the rules of evidence. That's the only thing that matters. It's the only thing that matters, ladies and gentlemen. So anyway, I'm a little fired up about that. Saw a lot of the comments. People are fired up about that as well. It is frustrating. Hopefully, people will behave themselves and the judge will allow us to move forward. All right. Before we get to the docket, again, let me remind you to go to crimetalksearch.com, sign up for that background subscription. All right. When you do, you'll be able to get a thorough background report on anybody here in the United States. It's going to have all types of information. It's everything that you want to know about somebody. So whether they're coming into your life or you're not sure if they should stay in your life, go check them out, ladies and gentlemen. You never know what you're going to find. And usually you find something that surprises you for sure. And also, if you want to get the merch, hit the link below. Go check it out. Stuff's going fast. Much surprised at how quickly and how many people are ordering merch. So check it out. All right, let's go ahead and open the record for Thursday, October 30th, 2025. How about the death of Leandro De Niro Rodriguez? That's right. Police have arrested 5 individuals in connection with the 2023 death of Leandro De Niro Rodriguez, the 19-year-old grandson of actor Robert De Niro, who succumbed to a drug overdose. Now, the suspects, Grant McIver, Bruce Epperson, Eddie Barreto, John Nicholas, and Roy Nicholas face charges related to the distribution of counterfeit prescription pills that allegedly caused the fatalities of 3 young individuals, including De Niro Rodriguez. Now, Leandro De Niro Rodriguez passed away back on July 2nd, 2023, in a one-bedroom apartment valued at approximately $950,000 within the Soprani Club residence on Wall Street in Manhattan. Emergency responders discovered his body seated in a chair with a white powdery substance on a nearby plate. The New York Medical Examiner classified the death as accidental, attributable to the combined with the toxic effects of fentanyl, bromazolam, and aprelazam, as well as ketamine and cocaine. Now, court records identified De Niro Rodriguez as victim 3 in the indictment, detailing a drug trafficking operation that supplied thousands of falsified pills to adolescents and young adults in New York. 3 of the accused were reportedly known by street aliases as Dizzy, another one known as T, and John John. According to the indictment, victim 3 acquired a combination of fentanyl-laced pills and Xanax from an unindicted female distributor designated as CC1, who obtained these substances from Epperson and Barreto. Text messages cited in the indictment reveal that CC1 cautioned victim 3 about the potency of the pills during the transactions in late June of 2023. And then on June 30th, she expressed reluctance, stating she did not wish to cause harm and noting the pills were not from a legitimate prescription. Despite these warnings, victim 3 proceeded to purchase 3 fentanyl pills and 2 Xanax tablets for $105 on July 1st, arranging delivery via car service to a friend's downtown apartment. The drugs were placed in a United States Postal Service envelope and delivered shortly after 9:15 p.m. At 1:05 on July 2nd, CC1 texted to check on the well-being, but received no response. His body was discovered later that morning. The indictment also referenced 2 additional victims. Victim 1, identified by sources as a 19-year-old Akira Stein, daughter of Blondie guitarist Chris Stein, died on May 30th, 2023, after obtaining drugs, and John Nicholas and Roy Nicholas. She reportedly overdosed twice prior to the lethal incident and was found unconscious in her family's Manhattan apartment. In a separate but related case, 20-year-old Sophia Haley Marks, known as the Percocet Princess, has been charged with supplying drugs to De Niro Rodriguez. Now, Leandro De Niro Rodriguez was the son of Robert De Niro's adopted daughter, Drana De Niro, age 51 at the time, and artist Carlos Rodriguez. Following the death, Robert De Niro issued a statement expressing profound grief over the loss of his grandson, who he referred to as Leo, and extended gratitude for public condolences. Building staff described the young resident as courteous and reserved, noting his habitual greetings upon entering and exiting the building, and the arrests underscore ongoing efforts to combat the proliferation of counterfeit pharmaceutical contributing to overdose deaths among youth. Now, hate to say it, but I've done this case. Did this case a couple years ago. Federal court, wasn't pretty, crashed and burned. Client got 30 years. And they always thought, oh, it's just pills, it's this or that, no big deal, right? But they always act like the caring drug dealer. Be careful. Smoke it, don't ingest it. That way you won't be able to supposedly overdose. Wrong. And so anyway, they act like, they're shocked and surprised when somebody dies. And every state has a statute like this. Obviously, it's the federal one. But if you distribute drugs to somebody and they die, the federal system, you start at a mandatory 20-year minimum to life in prison. And as soon as that jury, hears about the mom or the dad that found their kid that was dead because somebody was, trying to make $20 or something on a pill, jury doesn't take too kindly of that, particularly if they can link that person as the one who distributed the drugs. So tough cases, and it's tough all around. You'd hope that people wouldn't take prescription drugs unless they had a prescription from a doctor, but that's not the way it always works out. But you do it at your own risk for sure. And oftentimes it can turn out to be a deadly incident. I'm sure most people know somebody who has died from fentanyl or some sort of drug that was laced with fentanyl. I can think of at least 3 people that I know, people where a close family member has been involved in that type of situation. It's poison, ladies and gentlemen, poison. Next on the docket. It's always about the money. That's right. Idaho prosecutors are pushing for a full restitution in the Kohgerger case. So in a contentious legal battle over financial accountability in the aftermath of the brutal 2020 stabbing deaths of 4 University of Idaho students, prosecutors have rebuffed defense arguments against additional restitution payments from convicted killer Bryan Kohberger. Now, the dispute centers on approximately $27,000 in travel and lodging expenses incurred by victims' family during the court proceedings and amid revelations that Kohberger has received ongoing financial support while incarcerated. For all you know that aren't familiar, Kohgerger pled guilty back in July of 2025 under the Rule 11 plea agreement that spared him the death penalty in exchange for 4 consecutive life sentences plus 10 years for the burglary charge. The agreement explicitly allows the state to seek restitution for funeral expenses and reimbursement to the Idaho Victims Compensation Program. At sentencing, Kohgerger was ordered to pay $250,000 in fines and fees to the state, $20,000 civil judgment for each of the 4 victims, and nearly $29,000 to the compensation fund. However, the state amended its restitution request back in September of this year, seeking an additional $20,000 for the parents of the victims, Kaylee Gonsalves, and more than $6,900 for the mother of Madison Mogan. These funds cover unreimbursed travel and accommodation costs for attending hearings. Expenses prosecutors initially believed could be covered by the Crime Victims Compensation Program, but later deemed ineligible. So the defense cites some other funds. So donations and an inability to pay. Kohberger's legal team, led by attorney Ann Taylor and Alyssa Mathis and Bricka Barlow, filed an objection on October 7th of this year, arguing that the requested amounts do not constitute direct economic loss under the Idaho Code, specifically Section 19-5304. The defense highlighted substantial public donations received by the Gonsalves and the Mogan family through GoFundMe campaigns, which they claim specifically addressed these very expenses. And Mr. Kohgerger has no ability to pay now or in the future to pay restitution because he's serving 4 consecutive life sentences plus 10 years, the defense noted, emphasizing his incarceration as a barrier to earning income. The objection has drawn sharp criticism from victim advocates who view it as an attempt to evade responsibility. Stephen Gonsalves, Kaylee's father, has publicly expressed frustration with the situation where Kohberger's prison conditions in separate statements, though he has not directly commented on the restitution fight. Though the prosecutors countered with, legal precedent and evidence of the defendant's finances. In a response filed October 24th, the Latah County prosecuting attorney, through a senior deputy, Ashley Jeggs, dismissed the defense argument as contrary to Idaho law and public policy. And they were citing to a case decided by the Idaho Supreme Court, called State v. Cheney, Cheeney, and the filing asserts that victims are entitled to full restitution regardless of third-party payments unless those payers have a contractual obligation. In a response filed on October 24th, the Latah County Prosecuting Attorney's Office, through a senior district attorney, Ashley Jeggs, dismissed the defense's argument as being completely contrary to Idaho law, and they cited State v. Cheney, which is a case, Cheeney, and the filing asserts that victims are entitled to full restitution regardless of third-party payments unless those payers have a contractual obligation, a threshold not met by voluntary charitable donations like those from GoFundMe. Charitable donations, they cite in their brief, arise from voluntary generosity rather than legal obligation. The state responds, and they also cite State v. Schultz to underscore the policy imperative of making victims whole for losses caused by criminal conduct, irrespective of community support. Addressing the ability to pay claim, prosecutors reference State v. Bibby, Bybee, which holds that immediate financial constraints do not preclude restitution orders even for life sentence defendants. Courts retain discretion to consider factors like age and health, but the state argued that Kohberger's circumstances warrant enforcement. Now, a sealed exhibit attached to the filing, a summary of financial contributions to Kohberger during his detention at the Ada County Jail and the Latah County Jail, reveals a history of this defendant receiving financial compensation from family and third parties. Prosecutors did not disclose specifics, but noted that such inflows could be intercepted to satisfy the victim's claims. Now, the case's obviously international notoriety, the state added, heightens the potential for future revenue streams for Kohberger, such as from media deals or publications. And under Idaho Code, Section 1953-01, subparagraph 1, akin to the New York Son of Sam law, any profits from recounting his crimes would be escrowed by the state treasurer, with the victims able to claim those funds during a civil judgment within 5 years. And that's Idaho Code 19-5305 for those who want to go double check, make sure I'm not making this up. Anyway, speculation persists about Kohberger potentially authoring a book or cooperating on some other type of a project. Now, forensic psychologist Kathleen Ramsfeld, a former instructor of Kohberger, told an online paper that she would consider documenting his story, but insisted no profits would reach him, echoing her approach with the serial killer Dennis Rader, the BTK guy, where proceeds benefited the victims. All right. So a hearing on the restitution matter has been set for November 5th. And guess what? It should be streamed, so we'll be bringing it to you. All right. Now, the outcome could set precedent for balancing offender accountability with victims' rights in high-profile cases, particularly regarding the treatment of charitable aid and post-conviction earnings. So this gets a little interesting, and the judge, when he's ruling on this case as it relates to Kohberger having to pay restitution, clearly the intent of the judge was to make sure that basically no money whatsoever goes to Kohberger and that it would go to the family based upon the civil judgments and fines that the court imposed. I'm totally fine with that. The question then becomes whether the objection to the monies being requested for travel expenses, and these were going to be somewhat in anticipation of those, but a lot of the funds are apparently returned. So it's interesting. And I certainly don't want Bryan Kohberger to have to not pay what is due to the victims. You know, it's just not fair in life. Even if you're a convicted killer, you shouldn't have to pay more than what you're entitled to under the statute. I think the judge will ultimately come down that Kohberger will have to pay, and it'll probably go up to the Supreme Court there. I'm assuming that's not going to blow up his deal if he appeals anything, since it is as it relates to restitution. More than likely, they made their record. They'll see what happens. What are they going to do? What's the worst thing that happens to Bryan Kohberger? What are you going to do? Send him to prison for the rest of his life, right? It doesn't really matter. But it is interesting because what do we say here at Crime Talk all the time? It's always about the money, right? But we got to make sure that crime doesn't pay for the convicted, for sure. Got to make sure of that. Next on the docket, former Illinois deputy Sean Grayson convicted of second-degree murder. That's right, Sean Grayson, a former deputy with the Sangamon County Sheriff's Department in Illinois, was convicted on October 29th of second-degree murder in connection with the fatal shooting of Sonia Massey, a 36-year-old black mother of two, on July 6th. Of 2024. Now, Massey had contacted 911 to report a suspected prowler outside her residence there in Springfield, Illinois. Although prosecutors initially charged Grayson with first-degree murder, jury instructions permitted considerations of lesser offenses of second-degree murder. Following closing arguments that concluded on the morning of October 28th, the jury deliberated for nearly 12 hours before delivering the verdict. Members of Grayson's family displayed visible emotion, holding hands and weeping as the decision was announced. Outside the courthouse in Peoria, Illinois, demonstrators expressed approval of the conviction, with some chanting, "I rebuke you in the name of Jesus." Now, attorney Ben Crump and Antonio Romanucci, representing Massey's family in a prior $10 million civil settlement, stated that while they maintained Grayson's conduct merited a first-degree murder conviction, the outcome represented a second-degree accountability. Now, Sante Massey, a cousin of the victim, voiced frustration, remarking, "If an officer states he will shoot you in the face and then does so, the charge should reflect first-degree murder." Now, obviously, inclusion of the second-degree murder was a defense strategy, and the prosecution likely pursued an all-or-nothing approach on the first-degree murder, whereas the defense sought to mitigate risk by advocating for the lesser charge, obviously. Well, Grayson now faces a sentencing range of 4 to 20 years of imprisonment for second-degree murder, and under Illinois law, he may qualify for a day-for-day good behavior credit, potentially serving half the imposed term. Now, Massey's father urged the court to impose the maximum penalty, citing Grayson's apparent lack of remorse and demeanor during the proceedings. Now, body cam footage presented 3 times in court captured the incident in Massey's kitchen. It depicted deputies instructing her to manage a pot of boiling water on the stove. Grayson testified that he interpreted Massey's statement of, "I rebuke you in the name of Jesus," as a threat, and feared that she intended to hurl the hot water at him. He stated that he opted against using a taser due to the uncertainty, but its efficacy given her attire. Anyway, the deputy Dawson Farley, Grayson's partner at the scene, testified that he did not perceive Massey's actions as threatening and drew his firearm solely to support Grayson. The defense highlighted revisions to Farley's initial report following Grayson's indictment, alleging inconsistencies. In closing arguments, the district attorney, John Milheiser, described the pot as a giant, dangerous object and characterized Grayson's response as that of a bully who snapped under pressure rather than a frightened officer. First State's attorney, Mary Beth Rogers, emphasized that Massey's compliance and final words of apology, asserting that Grayson provoked the confrontation and could not claim self-defense. The defense attorney contended that Massey escalated the encounter by retrieving the pot and raising it, framing the shooting as a tragic but non-criminal response to a perceived danger. He urged jurors to focus on legal elements rather than policy violations or emotional considerations. Obviously, renewed examination of police use of force because of this case. I remember when this first happened, and I remember seeing the body cam video. It was not good for the officer. He got lucky on this, but probably this is what the jury thought that was appropriate under that, and it should be respected. In response to this whole situation, Illinois enacted the Sonia Massey Act in August of 2025, mandating enhanced background checks for law enforcement hiring. As you may recall, Mr. Massey had been fired from 5 different police departments in the course of about 4 years. He bounced around, apparently with a little bit of a hothead, so he won't be holding firearms again, and he's definitely going to prison as well. Sad case. Should never have happened, indeed. Next, a private investigator discloses more items recovered at the Singer David, spelled with a 4, and let's talk about it. So the private investigator retained by the owners of the Hollywood Hills property leased to singer David, whose legal name is David Anthony Burke, has reported recovering unconventional tools and prescription medication containers from the residence. Now, these findings emerge amid an ongoing police inquiry into the death of Celeste Rivas Hernandez, a minor whose remains were located in the front of a trunk of a Tesla that just coincidentally happened to be registered Mr. Burke. It was parked on a street, basically abandoned, gets towed. Anyway, the decomposed and dismembered remains of Miss Hernandez were discovered on September 8th with the impounded vehicle. Hernandez, who had been reported missing from Lake Elsinore, California, where she resided back in April of 2024 at age of 13, who would have turned 15 one day prior to her discovery, dismembered in the trunk of the Tesla. Now, police indicate she had likely been deceased for an extended period of time. Anyway, on September 17th, the Los Angeles Police Department homicide detectives executed a search warrant at the $4.1 million property, seizing multiple items of evidence connected to the investigation. Now, the residence owner engaged an investigator by the name of Stephen Fisher to ascertain whether Hernandez had ever been present at the location, and if so, the timing of any such visit. Fisher's examination included review of surveillance recordings, neighbors' interviews, and property searches. He reported locating multiple tools and equipment atypical for a residential setting in an urban area, more commonly associated with agricultural use. I wonder if they're sharp for dismembering type of jobs. Anyway, one such item remained in its original shipping materials, suggesting a recent arrival. Fisher described these objects as potentially combinable for unspecific purposes and noted their incongruity with household needs. He has informed the Los Angeles Police Department of those items that were recovered. Additional items recovered include containers of prescription pain relievers and drug-related implements. The investigators characterized the resident's overall condition as otherwise unremarkable. Now, he previously described certain items as possessing characteristics that could facilitate harm or a disposal of human remains, though no further specifics were provided in the latest statements. Now, no direct evidence confirms Hernandez's presence inside the property. However, Fisher cited a neighbor's account of observing a girl matching her description seated on the curb outside, apparently awaiting entry. Personal belongings indicative of multiple adult occupants, both male and female, were found in the guest area, none attributable to Miss Hernandez. Surveillance footage analysis revealed the Tesla, exhibiting dents and mud accumulation, was last operated on July 29th of 2025, with the driver's identity established but not disclosed. The vehicle was subsequently parked by the intersection of Doheny, D-O-H-E-N-Y Place, and Bluebird Avenue until its impoundment in early September. Now, records confirm Burke was in Los Angeles on the date before departing for a performance in San Francisco, initiating his tour. Fisher's review suggests a small group of 2 to 4 close associates resided with Burke and had access to the car. Following public disclosure of the case, the individuals reportedly ceased social media interactions and removed shared content. Now, Hernandez's cause of death awaits final autopsy and toxicology results. The matter is classified as a pending death investigation with no homicide designation or named suspects as of yet. The Los Angeles Police Department has not commented on Fisher's findings, and no response has been issued on behalf of Mr. Burke. Now, sources acquainted with Hernandez asserted that she and Burke maintained contact initiated via social media when she was approximately 11 or 12 years old, evolving into a prohibited relationship. Her last communications occurred in late June of 2024, though Fisher's reference documentation indicating her survival until at least January 2nd of 2025. Now, prior to her disappearance, police responded to 11 calls at the Hernandez's family residence. 22 additional calls followed, involving disturbances, including vandalism and alleged assaults. Hernandez had absenced herself on multiple occasions, including an initial departure back in February of 2024, with subsequent subsequently returning and departing once again back in March and April of 2024. Now, Burke vacated the property shortly after the search, canceled remaining tour dates following Hernandez's identification, and has made no public statements. His cooperation with police remains unconfirmed, and no charges have been filed. Property records indicate he recently transferred ownership of 2 Texas residents to his mother. His present location is unknown. We'll give him the presumption of innocence. Who knows who had access to that particular vehicle? Maybe video will tell us, at least on the day that she was dropped off, right? Next, Austin Drummond gets to take a little trip. Austin Drummond, the individual accused of 4 murders in Tennessee and currently awaiting trial, has been moved from the local county jail to a state correctional facility. Police attribute the transfer to misbehavior while incarcerated. So Drummond, facing allegations of killing 4 individuals in a rural area of Tennessee and leaving an infant unattended, attended a preliminary hearing on Thursday. Now, during a court session on Monday, the Lake County Assistant District Attorney outlined Drummond's infractions, noting that he received disciplinary action for possessing Suboxone strips, an unauthorized controlled substance within the jail. And the district attorney further indicated that Drummond repeatedly obstructed his cell door using items such as paper and excrement. That's right, he's one of these guys. Ugh. Anyway, officials concluded that the county facility, which accommodates 149 detainees, does not possess adequate resources to address Drummond's disciplinary actions, effective immediately. In contrast, the state prison system provides enhanced staffing facilities and targeted interventions for management challenges. Drummond will stay under state supervision until his trial, set in May of 2026. The specific institution housing him remains undisclosed. Every now and then, ladies and gentlemen, you get these guys that just cannot simply get along with anybody at all. Their management problems, they will flood their cell by stuffing toilet paper down there. They will take their own excrement and throw it against the walls and throw it at deputies. You know, we're not talking mentally ill people, or maybe they want you to think they're mentally ill. But sometimes there's some people that just need to be locked up. I know that's hard to say as a criminal defense attorney, but it's true. There are some people that just cannot function in society. And if you can't function and want to assimilate to being a productive member of society, guess what? The state will lock you up. Now, the relocation of charges related to the July 29th murders of 4 relatives, James Matthew Wilson, who is 21, Andrea Williams, age 20, her brother Brandon Williams, age 15, and their mother, Courtney Rose, who is 38. If you do the math, she was a young mom. Additional accounts include kidnapping and deserting a newborn child discovered on an unfamiliar residential property. Drummond's prior record demonstrated a history of aggressive behavior. Beginning at the ripe age of 17, he faced aggravated robbery charges stemming from a retail establishment incident, and then subsequently he was accused of intimidating jurors in that case and attempted murder for an alleged assault on another person while in custody. Notwithstanding this substantial background, Mr. Drummond secured release on bond prior to the quadruple homicide allegedly taking place, and he was free on bond at the time of his alleged July incident as well. In an earlier interview from custody, Drummond stated that he had served as a confidential informant for federal agents and identified as Vice Lord's gang affiliate during prison. He claimed that his identity was compromised in a period leading up to the killings. Anyway, Drummond's actions in jail seem motivated by resistance to regulations rather than protective instincts. And it's, applying feces to cell doors offers no security benefit to the individual and instead creates disturbances affecting the entire facility. Anyway, the transfer to the state institution could hinder pretrial proceedings, potentially restricting Drummond's consultations with legal counsel, which, well, sometimes if you're misbehaving, guess what? What can you do? What can you do? Next on the docket, officer, do you have pants on? That's right. Take a look at this video. Detroit police officer Matthew Jackson shows up on a Zoom hearing without pants. Judge Sean Perkins says, quote, "Officer Jackson, good morning to you. Can you put your appearance on the record, please? Officer Jackson raises his hand. Judge Perkins, you got some pants on, officer? Officer Jackson responds, no, sir.
Officer Jackson, badge number 3919, out of the 12th precinct.
All right.
Officer Jackson. He got an Oscar camera, Judge.
You got some pants on, officer?
Sir, they're in the... No, sir.
Officer Jackson, okay, Miss Lee.
Next on the docket, this day in legal history, 1938, October 30th. Orson Welles broadcasts The War of the Worlds on CBS radio, causing a public panic and resulting in lawsuits over fraud and free speech, obviously testing some First Amendment limits on broadcast media and influencing future FCC regulations on emergency communications. Next, our quote of the day. Here we go, ladies and gentlemen. If criminals wanted to grind justice to a halt, they could do it by banding together and all pleading not guilty. It's only because we have plea bargaining that our criminal justice system is still in motion. That doesn't say much for the quality of justice. That was Dorothy Wright Wilson, 1974. I have said that myself many a time. If everybody said not guilty, let's say to have a trial, case would be getting dismissed left and right, ladies and gentlemen. There are not enough judges, not enough prosecutors, not enough courtrooms to do all of those trials. Now, it used to be before they kind of basically legalized plea bargaining. If you didn't plead guilty to what you were charged with, you went to trial. And we introduced plea bargaining in the late 60s and, where it really got going. Next on the docket, our dumb criminal of the day. What a tragic symphony of despair for Halloween enthusiasts everywhere. A Florida man has been accused of obliterating pumpkins worth a whopping $500, as per those ever-reliable court records. In a nocturnal escapade that surely ranks as high art, police claim 31-year-old Aaron Thompson emerged under cover of darkness last week to annihilate approximately 80 pumpkins neatly arrayed before the Target in the Tampa Bay vicinity. Security footage, the authorities insist with a straight face, captured Thompson selecting pumpkins from the display boxes and heroically slamming them into the pavement at the witching hour of 1:15 a.m. on October 21st. Arrested mere days later upon his bold return to the crime scene, because why not? Thompson was escorted to the loss prevention office and graciously shown the video evidence. When queried if he could identify the pumpkin smashing virtuoso, he reportedly declared, "Hey, that's me," with a flair of a confession at a curtain call. Pressed on his motives from the Gourd genocide, Thompson allegedly explained that someone was messing with him on Facebook and it made him mad. A profoundly intellectual rationale, no doubt. Officers noted he remained utterly unrepentant, casually departing the carnage to catch some beauty sleep. The resulting pumpkin puree, valued at approximately $472.14. Slapped with a felony criminal mischief charge, Thompson now languishes in the county jail on a $5,000 bond. His criminal resume boasts prior triumphs in burglary, battery, trespass, criminal mischief, and reckless driving. And for his day job, the arrest report lists him as a violinist, a title benefiting his past performances with the Pinellas Park Civic Orchestra, elite first violin section, where he no doubt channeled similar passions into his instrument. Good day, sir. You are our dumb criminal of the day. All right, ladies and gentlemen, that's all we have for today. Thanks for watching. We'll see you next time. And remember, the Constitution matters.